Hello, everyone, and welcome to our presentation today on opioid use and addiction under the ADA. Our speaker today is Aaron Konopaski, but before I introduce him, I would just like to go over a few of the expectations or ground rules for today's presentation. First of all, it is being recorded. You should know that. The recording will be taken and posted on YouTube later, and all attendees will be sent a link for that. As far as questions today, as we go through the presentation, obviously you can use the chat, and we will try to gather those questions and ask. If you will be muted in general, but if you want to ask a question, you can unmute yourself and ask that question. Or there will be times when Aaron will also ask if there are any questions, so we'll take care of it that way. So to get started, just would like to introduce Aaron Konopaski. He's a senior attorney advisor, Office of Legal Counsel at the EEOC. You'll see he's been dealing with this issue and working with other agencies for a while, and he'll speak about that as well as he goes through the presentation. So, Aaron?
Hi, thank you. Yeah, this is Aaron Konopaski, and I'm glad you could all make it for today, talking about opioids under the ADA. I'm going to get right into it. I'm going to start with a video. This presentation was developed partly in connection with the initiative to stop opioid abuse and reduce drug supply and demand, which is a government-wide effort to combat the opioid epidemic. And this is a video that the Office of National Drug Control Policy put out together with the Truth Initiative as part of the outreach for that program.
Aaron? Oh, seem to have lost Aaron temporarily.
Hey, have you lost me still?
No, I got you now. Got you back.
Okay. So that was a somewhat disturbing video that illustrates, it's a true story, illustrates the power that opioids can have. And one of the main points, as you saw, was that the addiction can happen in just 5 days of normal prescription use. That's part of what...
I'm sorry, Aaron. I don't know if you forwarded the slides. The video didn't show, at least I didn't, and I think we get some comments that the screen. Are you advancing the slides? I just advanced the slides. If other people could tell me whether they can see that.
Can you see the next slide?
Let me see. As I see is the first slide, the title slide. And that's what other people are seeing as well from the chat. So you're advancing it?
Yep.
Okay, maybe we'll have to
take over as presenter, maybe.
Yeah, so, well, I was advancing it early and they could see it, but let me see.
All right, can you see the second slide now?
Yes.
All right, let's try it one more time.
Can't hear you, Aaron.
Okay, I think I'm back.
Great.
Yes, we've been having very, very exciting technical issues right up until the beginning of the presentation. So hopefully there's going to be no more videos, and so hopefully we're smooth from now on. But the video, I think, does a good job of presenting in a kind of dramatic way, a way that really lets you feel the depths of the problem. Some of the things that we're going to end up talking about that are going to be relevant under the ADA. And the two things that I want to focus on, or will be focusing on, is that the addiction can happen in just 5 days and can be the result of prescription use. And that's going to become important a little bit later. You're seeing some numbers put out by HHS. It's a large problem, as you can see. 2.1 million people currently addicted. And the total cost to the U.S. economy is something like $500 billion a year, which is roughly 2.5% of the U.S. GDP. So it's a big problem, and one that I think we're going to see a lot more of. And it's a problem that's increasing in magnitude. Not only is it large, but it's increasing, and it's increasing at a faster rate every year. So as you can see, ER visits for overdoses increased by 30% in 1 year. That is a huge increase. And there are lots and lots of opioids on the market right now. There's enough prescribed per year to keep every person medicated continuously for a month. All right, so a large problem, one that's likely to come up more and more as time goes on. I thought I would start the main presentation with a little bit of background, just because sometimes people are unfamiliar with terminology, especially in a field that's specialized like drug addiction. So I thought it might be helpful to go through some of the background information here. First of all, just what is an opioid? When I first started working in this area, I did not really know what an opioid was. And so I've listed some on the right: codeine, morphine, oxycodone, common ones, hydrocodone. Fentanyl is one of the newest synthetic ones. Opiate, the term opiate, you might have heard that. That means a natural opioid. There are natural opioids and synthetic opioids. What it does is it binds to your opioid receptors in your brain to reduce the feelings of pain, but it can also produce euphoria and respiratory depression. In other words, it can make you stop breathing or breathe very shallowly. So the drugs on the right, a lot of them, you might be surprised, are quite common. Codeine, Percodan, and Percocet are brand names for oxycodone, right? So all of those are opioids. You also might run into some different terminology in the addiction field: use, misuse, abuse, dependence, and so on. Misuse usually means taking a prescription medication for a purpose other than the intended purpose, or in a manner inconsistent with prescribed directions, or without a prescription. And abuse is intentionally misusing it in order to experience a euphoria or high. Right, so in the addiction field, people talk about misuse and abuse. One important thing to note is that misuse and abuse don't necessarily map directly onto illegal, and this will be important when we get to the illegal use exception a little bit later on. There's also the idea of dependence or physical dependence. That has to do with tolerance, where you have to take more and more of the drug to achieve the effect, and withdrawal, which is where you have physical symptoms, unpleasant symptoms that come if you stop using the drug. Right? And addiction is usually meant to refer to compulsive use that has harmful consequences. All right, so they're all somewhat informal, and some people use them in different ways, but these are the common definitions that you'll most likely run across. There's also opioid use disorder, which is in the DSM-5, the Diagnostic and Statistical Manual, which is the psychiatric diagnosis manual. In the latest edition, there's a mental disorder called opioid use disorder, or OUD. It's got a long, as you can see, in technical definition. I won't read through all of the things, but it's got tolerance and withdrawal in there at the end. And sorry, I'm just getting a call. The audio is still working, right?
Yes.
Okay, so I'll just keep going. And as you can see, it involves fairly serious consequences. Great deal of time spent to obtain, use, or recover. There's cravings, urges, recurrent use resulting in a failure to fulfill major role obligations at work, school, and home, and so on. And so this is a medical diagnosis. It's in the DSM-5. And it's what we would call an impairment under the ADA. Impairment, as you know, just means medical condition, and OUD is one of them. I also wanted to talk just a little bit about drug testing. It's sort of complicated, and a lot of times it's hard to tell what's going on. There are what they call panels, or urine panels, and what it is, if there's a 5-panel urine test, that essentially means that there are 5 tests performed at once on the sample. And in a standard, so-called standard 5-panel test, usually opiates is going to be one of those that are being tested for. And what it's looking for is evidence that you've used heroin, morphine, or codeine, right? So there's no way usually to tell which of those 3 things that you've used, because heroin, when it's processed in your system, breaks down into some of the components of morphine, and morphine breaks down into the components of codeine, so they sort of turn into each other, and so there's usually no way to tell which of those 3. So what the testing person knows is that there's been a positive result for one of those 3 drugs. The panel tests for urine have a relatively high false positive rate. Right? They're not all that accurate, and they're usually followed up with confirmatory tests. Now, other opioids, besides heroin, morphine, and codeine, you can also have tests done for those, and sometimes in 10-panel tests or 12-panel tests, you might have a separate test for methadone, for example, or one of the other opioids. And each of the other opioids are going to be tested for separately, and you will be able to tell which of those it is, because the chemical signs are specific to each one of those. So if there's a test for oxycodone, then you know it's oxycodone that the person is using. I think the last terminological issue that we're going to talk about is MAT, or MAT. It stands for Medical Assisted Treatment. And this is really the state of the art for treatment right now. It's the most effective treatment available for opioid addiction, or OUD. And it includes counseling, behavior therapy, and medication. Medication assists the therapy by reducing cravings and withdrawal symptoms, and allowing the person to concentrate on recovery and on the behavioral therapy and the counseling, without having the kind of distraction of the terrible physical side effects. Methadone is kind of the best known of those medications. That has to be administered daily in a clinic. Kind of a newer one is buprenorphine. Sometimes you might hear it called Suboxone. Suboxone is a brand name, and it contains buprenorphine plus another drug, naloxone. That can be dispensed in a physician's office. It doesn't have to be in a clinic, and it can be dispensed less frequently. These things, methadone and buprenorphine are opioids, right? So if we go back to the list of opioids, you notice that they're on that list. But the way that they're used in treatment is to minimize or eliminate euphoria while reducing cravings and withdrawal symptoms, right? So they are very unlikely to be misused or result in overdose. And additionally, taking them is usually pretty safe. And HHS has put out a lot of material assuring people that they may safely be taken for months or even years, and while the person is in recovery, and the person will be able to function quite well. There's also a big connection to employment, by the way. Nearly 1 million people did not participate in the labor force in 2015 because of opioid addiction, representing a loss of 1.5 billion work hours. So it's a big reason why people are out of the workforce. And staying employed is an important determinant of recovery as well. If someone has a job to come back to, then it's much easier for the recovery process to proceed than if the person knows they're going to be unemployed by the end of it. So a very strong work connection there, and so a connection to some of the work that we do ultimately. Okay, so getting into the ADA portion of the presentation, I wanted to start off by talking about coverage, by itself, and we're going to talk about the illegal use exceptions and how they apply and so on. And we're going to go through that once, and then we're going to apply the things that we talk about in this section in sections on reasonable accommodation and disparate treatment and so on. So if it goes by fast the first time around, that's okay. We'll be working with the conclusions and applying the principles that we talk about here in the context of particular kinds of claims. Okay, so just to remind people of what we're talking about, the ADA offers protections, certain protections, but only for what they call covered individuals. And the protections in particular are the right to reasonable accommodation, the prohibition against disparate treatment on the basis of disability, provides the right to challenge qualification standards that screen individuals out on the basis of disability, and prohibits disability-based harassment. All right, so these are all protections that are given to covered individuals. And a person is covered under the ADA if he or she has a disability as defined by the ADA, and neither of the two illegal use exceptions apply. All right, so that's how we're going to be talking about coverage. Disability, I'm sure you're all familiar with the definition, and so I'm not going to talk a lot about the definition, but just note that, just really quick, a condition substantially limits a major life activity, an impairment, which is a medical condition that substantially limits a major life activity, which means that it would result in substantial functional limitations in the absence of treatment during an active episode. All right, so under the new definition, ever since the ADA Amendments Act came into effect, under this new broad definition of disability, the limitations that it imposes don't need to be permanent, long-term, or severe. And as you can see, they're kind of hypothetical, right? They're the limitations that would be imposed in the absence of mitigating measures, right? If the person was not getting treatment or other kinds of compensatory mechanisms, right? So we also see that the definition of disability has another two prongs, as we like to call them, a record of prong, right? So if someone has a record of or a history of a substantially limiting impairment, that's another kind of disability. And being regarded as having an impairment, that's another kind of disability. And being regarded as is basically just means being treated as having. All right, we're not going to spend a whole lot of time on those, right? But just to remind people that they're there. So applying this to opioid use, how does disability apply to opioid use? Now, remember that we went over the definition of opioid use disorder, and it had some fairly significant functional limitations associated with it. People were limited in fulfilling their roles at school and at work and so on, and there were other kinds of things that were happening as well. And because the definition of OUD requires those significant functional limitations, it's almost certain to be substantially limiting. Right? I think if the person is diagnosable as OUD, the person is usually going to qualify as having a disability under the ADA. It's going to affect things like sleep, concentration, regulation of thoughts and emotions, brain functions, and so on. All right. So translating that conclusion over to history of someone who had OUD in the past, it almost certainly has a history of a substantially limiting impairment. And not only that, even setting OUD aside, a person who uses opioids for some other reason might have a disability if the underlying medical condition that's causing the pain, which is the reason for the opioid use in the first place. So if the person has some sort of back condition, for example, that's why the person is taking opioids, then even if the person is not addicted, they still might have the disability of having a back impairment that substantially limits a major life activity. So that could be a source of disability as well. And even if the person is addicted or has OUD, they might also have other disabilities associated with the underlying medical issue, or things that are comorbid with OUD. Right? So you often see OUD and PTSD come together. So they might have multiple disabilities as well. Important to remember, because even if the person is kind of ruled out because of OUD, there might be some other basis for coverage having to do with something that's comorbid or have to do with the underlying impairment. All right, so that's disability. Now, how about the illegal use exceptions? This is where it gets a little more complicated, and there are actually two. They can both be found in 29 CFR 1630.3, but they're in different little paragraphs. D3 says disability does not include psychoactive substance use disorders resulting from current illegal use of drugs. All right, so if you have OUD, and if the OUD results from current illegal use of drugs, then the OUD is not a disability. Okay, that's ruled out by what I'll call the first illegal use exception. In addition to that, there's no prohibition against actions that are based on current illegal use of drugs. All right, so the employer can act on the basis of current illegal use, and nothing in the ADA is going to prevent that. All right, that's what I'll call the second illegal use exception. Illegal use, what does that mean? It means what the Controlled Substances Act says it means. In the ADA, it specifically refers to the Controlled Substances Act. Right, so it's even if there are laws relating to opioid use in a state level or some other federal law, it's the CSA that controls whether or not use of opioids is illegal for purposes of the ADA. All right, so what is illegal under the Controlled Substances Act? Use of heroin is always illegal. And just to summarize the next 2 points, use of prescription opioids that are obtained in an illegal way. All right, so going to the doctor and misrepresenting your medical condition or engaging in fraud is one of the ways it can be illegal. Or obtained from someone else, right? So whenever you use someone else's prescription, that violates the Controlled Substances Act. Right? So the question is basically whether you obtained the drugs legally or not. That's the key to whether it's illegal use under the ADA. And so you can see, by the way, some of the differences between misuse and illegal use. Some kinds of misuse are not going to be illegal, using drugs in a way that was inconsistent with the directions, for example, is going to be considered misuse and potentially abuse in the drug addiction community, but it's not going to violate the CSA because you obtained them legally. If they were prescribed to you for a legitimate medical reason, then using them, even though you're using them in a different way than what was prescribed, is not going to violate the CSA. So what does current illegal use mean? There's no agreement on this. This is an issue that's gray area. It's litigated, and some courts stretch the meaning of current wider, and some sort of squish it. So there's going to be no hard and fast answer to that question. Some guidelines that I think are worth keeping in mind is that the statute clearly contemplates the possibility of someone who is in addiction treatment but is not currently engaging in the use of drugs. Okay, so if somebody is enrolled in a MAT program, for example, the statute clearly contemplates the idea that someone like that might not be currently engaged in the illegal use of drugs. Somebody who is caught and then runs out and signs up for an MAT program just because they were caught, that person probably is going to be found to be currently using illegal drugs. But if the person is actually enrolled and is taking steps towards recovery, it seems to be contemplated in the ADA that that's not going to be current use. Some courts have required more, though. They've required a significant period of recovery in order to say that the person is not engaged in the current illegal use of drugs, assuming that the use was illegal. All right, so there's a little bit of uncertainty in this area. Our appendix in our regulations says that illegal drug use is current if it happened recently enough to indicate that the individual was actively engaged in such conduct. All right, so it's not the most definitive statement, but hopefully it can help people trying to apply the exception a little bit. Moving on to the second exception, what does it mean for an action that the employer takes to be based on current illegal use? I'm going to make the point that that's a little bit unclear as well, but there are some things that are clear, namely where an individual's current drug use is legal, right, the exception doesn't apply. Right? So if a person has prescribed opioids because of a back impairment and is using the opioids for that, that's not and the employer fires the person, that's not going to be based on current illegal use of drugs because there's no illegal use. The employer's belief that the use is illegal, suppose the employer says, well, I thought that the person was engaged in illegal use, that's not sufficient to trigger the exception. Right? So the person's use has to be actually illegal. Now, suppose that the use was actually illegal. If the employer acted because the drug use was illegal, then the exception certainly applies. All right. So if the person is engaged in the current illegal use of drugs, and the employer finds out and says, "I'm firing you because that's illegal," then that action is not going to violate the ADA. It's a little bit unclear. And there's room to disagree on this, but it's a little bit unclear whether when the employer acts for a different reason, right, and the use is illegal, whether the employer is truly acting on the basis of illegal use. Right. So the question is, if the person is using illegally, but the employer says, "I'm going to fire you because I just don't like people who use opioids." The question is, are they acting on the basis of illegal use? And I think there are arguments to be made on both sides. But one major lesson that I think comes from all this is that if an employer wants to rely on that second exception, really it should find out whether the opioid use was in fact illegal. Right? So if the person is using it legally, then the second exception is not going to apply. Right, And I think that the confusion about this might come from the fact that traditionally or usually when we're talking about drug addiction, we're thinking of things like cocaine and so on, where any kind of, and heroin, where any kind of use is illegal use. But when it comes to prescription drugs, it's different, right? So the drug test comes back positive, but the test can't tell you whether or not the person is using it illegally. All it can tell you is that the person's used it. And so if the employer wants to ensure that its actions are going to be protected by the second illegal use exception, then it should make sure that the person's actually engaged in the illegal use of drugs before taking action on that basis. Maybe I should stop there and see whether or not there are questions. You can type them in, or if someone wants to unmute, they can ask a question there. Okay. Well, is somebody there?
Not seeing or hearing anything, Aaron.
Okay. So let's apply all these things when it comes to reasonable accommodation. As you all know, reasonable accommodation is some change in the way things are typically done that enables the individual to do a job, apply for a job, or enjoy equal access to the benefits and privileges of employment. And again, just a reminder, there's no accommodations for people who are only covered under the regarded as prong, right? So you have to have an actual disability, an actual impairment that substantially limits a major life activity, or a history of such an impairment in order to be qualified, or in order to be entitled to a reasonable accommodation.
Aaron, there was a question that sort of goes back to the earlier that came in a little late before you got too far into this area. So the question is, so basically management would ask for proof of prescription in order to justify their belief that the use is illegal. The burden of proof that is legal is put on the employee?
Right. Well, yeah, I mean, burden of proof is of course a legal term which goes to litigation, and so I want to shy away from using that. But yeah, I mean well, let me say this. When drug testing is done by a federal agency, right, there are all sorts of regulations. The drug testing is heavily regulated by SAMHSA, which is a branch of HHS, and there are they're very careful about how the reporting works. And so there's an independent medical examiner who gets the results initially, and if the results come back positive, then the independent medical examiner is supposed to try to figure out whether the use was illegal, right? And he or she is going to ask the person for evidence of a legal prescription or some sort of explanation as to why the test came back positive. In some extreme examples, as I understand it, if you ate a lot of poppy seeds, sometimes it can come back positive. But probably that's not going to happen. But the independent medical examiner is then going to try to evaluate that and see whether or not the use was actually illegal. And if the use was legal, is not going to report the result as positive back to the agency, right? So there's actually a wall built up between the employer and the test, where the employer really does only find out whether or not the use is illegal. Those regulations apply in the federal context, but they don't necessarily apply in the private sector, right? So you could see cases where an employer hires one of these testing operations, right, and says, well, I'm going to use a 10-panel test. I'm going to test for this, this, and that. And maybe it just depends, I think, on the contract that they sign with the testing facility. They might see those sort of raw test results. And in that case, if the employer doesn't ask for proof that the positive result is the result of legal use, then the employer is taking a risk there, because if they fire the person and it turns out that it was all legal, then they might be on the hook for disability discrimination. So it's in the employer's interest to try to figure that out, I think. And unlike in the case of something like cocaine or heroin, they can't sort of automatically and knee-jerk way reject the person and kind of be assured that their action is going to be protected under the second exception.
So a follow-up here, they're asking if there was any proof that the manager or supervisor has to provide to support their suspicion. I mean, they can't use those tests, or what would they use to support their suspicion as an employer?
Well, there are no hard and fast rules about that. I mean, I think that what it would come down to is, in the litigation context, what can the employer show, and what can the individual show to establish that the use was illegal or legal? There's no. Usually, if it's the employee, the proof is a legal prescription for opioids that can explain the test results. Right? If the person can produce some prescription for oxycodone and say, "Well, I was taking it for my back" or something like that, then I'm not quite sure what else anyone would expect for them to produce. I think if the employer acted on the basis of the test under the assumption that it showed illegal use, and then the person doesn't come forward with proof, and it comes to litigation, I think that the person then is taking a risk that there's going to be an inference that what they did was illegal, because if it were legal, they could produce a prescription, and so why aren't they producing a prescription? In real time, when these things are being processed, there's no sort of person that they have to refer the decision to, right? The manager is going to make the decision on the basis of his or her best judgment. But usually the key is whether or not the person can produce a prescription, and that's not foolproof, of course, right? Because as we all know, if the person, even if the person has a prescription, they still could be using opioids illegally. Like they could be using extra ones, or they could have obtained the prescription through fraud or misrepresentation, right? And so there is no kind of 100% proof on either side, but it's going to come down to, I think, what the person can show in court, whether the use was illegal or legal.
Okay, thanks.
One of the things that you might be getting at is that, one strategy to try to avoid all of this is for the employer to simply just not assume that the use is illegal, right? That would be one way to try to lessen exposure to liability, is to just not rely on these illegal use exceptions and just to assume that the use is legal and then see what their obligations are under the ADA. Then that would be one way of reducing liability. Okay, so past OUD, let's see how, in the context of reasonable accommodation, the coverage issue applies in the case of past OUD. So suppose somebody had an addiction in the past and is recovering or has recovered. In that case, that individual is almost certainly covered. Okay, almost certainly has a record of a substantially limiting impairment, because there's no current illegal use. So you might get accommodations that the person is entitled to. For example, a scheduled change or leave to attend a Narcotics Anonymous meeting, or some sort of ongoing rehabilitation program. Right? If there's no current illegal use, then you can ignore those exceptions. The person is covered under the record of prong, right? And they're therefore eligible for the reasonable accommodation. So you would have to consider the accommodation in that kind of case. What about current OUD? Well, again, it sort of breaks up into two subcases. If the current OUD involves illegal use, then the person is not going to be covered, and there's going to be no entitlement to reasonable accommodation. One of the two exceptions is going to apply. However, if the OUD does not result from illegal use, the individual is almost certainly covered. Right? The OUD is almost certainly substantially limiting, and because there's no illegal use, neither exception applies. Right? So two very different results depending on whether the use was illegal or legal. And so some example accommodations could be schedule changes or leave to enter addiction treatment, right? Or accommodations to address the side effects of medications if necessary, like nausea or vomiting. Right? So I think this is one area where people might kind of be surprised because a lot of the outreach materials that we've seen in the past all are talking about previous addiction, right? If you are a recovered addict, then you can get protection under the ADA. Well, this is a case, because some of the use is legal, this is a case where current active addiction could be a disability. It might not be excluded, right, because it might not involve illegal use, and so you might be able to get an accommodation because of it. And sometimes this is something that people kind of overlook because there's a tendency to ask, well, are you currently addicted? Well, current addiction is not covered, and so I don't have to give you a reasonable accommodation. But that's in the case of opioids and other medications that you can become addicted to that are prescribed legally. You can't do that automatically, and be assured that the exception is going to apply. You're taking a risk if you do that. So in some cases, you might have to consider, for example, somebody who wants to enter addiction treatment, potentially giving them a reasonable accommodation for that, just like treatment for some other medical condition, surgery for this or that. This would be sort of analogous. All right. You could also be covered from on the basis of related conditions, right? So the back injury, for example, or PTSD, which is often comorbid, and the person might be entitled to reasonable accommodation for that. Accommodation for the back injury, right? So there are different ways that the reasonable accommodation obligation can arise, right? It could arise from past addiction, current addiction, or something that's not addiction but related to opioid use, like an underlying impairment or a comorbid condition. This is just a little summary thing where, there are always further issues, not a lot specifically to do with opioids, but I thought I'd list them anyway. The reasonable accommodation is only going to be required, of course, if the covered individual requested the accommodation. The individual will be able to perform the essential functions of the job, or in the case of leave, the individual will be able to perform the essential functions of the job after the leave is over. Right, that's sort of the version of qualified when it comes to leave. And if the accommodation will not impose undue hardship on the employer, right? So the person might be entitled to leave, for example, as a reasonable accommodation to enter treatment. If giving the person the leave is not going to cause undue hardship, the person is reasonably expected to be able to return afterwards and perform the essential functions of the job. The person has put the employer on notice that they have a disability and need the accommodation, and so on. So, all of those normal requirements for reasonable accommodations apply here as well. So I don't want you to forget those there. Okay, so I'm just going to pause for 1 minute to make sure that there aren't questions specific to reasonable accommodation. We're going to see some of the same things come up again in disparate treatment, so I can continue, but I'll keep my eye on the chat box to see whether something comes up. So again, when it comes to past addiction, coverage is not usually much of an issue when it comes to disparate treatment. The individual is almost certainly covered because OUD is almost certainly substantially limiting, and if the person is not anymore addicted, is not using the thing illegally, then the exceptions don't apply. Right? So suppose that an applicant is rejected after the employer learns that a gap in employment is due to addiction treatment. And this is actually a kind of case that you see, I think, probably most often when it comes to employment discrimination, is that there's some knowledge that the person was addicted or sometimes is in recovery and is taking Suboxone or methadone, and the person might be able to establish coverage under the record of prong. Current use, again, it breaks up into two different parts. If the current use is legal, right, again, neither the illegal use exceptions apply. They're not relevant, and so the coverage just depends on the normal things, whether the person has a disability, excuse me, could be under the regarded as prong or under the actual disability prong, right? If OUD is the disability, then you could get coverage that way, or if the underlying impairment is a disability, you might be able to get coverage that way as well.
So, Aaron, let me ask a question about the distinction here between past and current, in the sense that this is the kind of thing where somebody could say, well, you know, I stopped using it 2 weeks ago. I mean, what's the line there between saying, okay, does it have to be documented somehow that it's in the past versus current? Is there any information that you know about that just sort of set that out?
Yeah, so that's the tricky question, really. So going back to this slide here, this is what current means, essentially. And, you know, different courts have applied different standards, just to be perfectly honest. One touchstone is the appendix. It says that illegal drug use is current if it happened recently enough to indicate that the individual is actively engaged in illegal use. But that's fuzzy. That's a gray area. And I think similarly, whether or not the person has a history of a disability versus a current disability, if the person is in recovery, for example, at what point does it become a history of coverage rather than a current addiction? I don't think that there's any hard and fast answer to that. But, you know, I mean, if, for example, a plaintiff is arguing for coverage under the record of prong, you know, the principles of applying the new definition of disability, if the condition is in remission, right, then the person might even have a current disability, right? So there are different ways, I think, that you could try to argue that, but again, I don't think that there's any definitive answer to that question. And in practice, there might not be much of a difference anyway, because I think probably the only question that's going to come down to is whether or not the person is currently engaging in illegal use, because I think otherwise, I mean, it doesn't really matter whether it's a history of or current in terms of whether or not it's disparate treatment, right, or whether or not the person is entitled to reasonable accommodation. You can get the reasonable accommodation probably under either of those prongs. It's probably going to come down to legal versus illegal use. But, you know, you might see as a litigation strategy someone try to establish record of to try to sort of lessen the idea that the person is currently using. But I think it's a gray area.
Thanks.
Actions based on current use if current use is illegal. This is where it's not quite as clear legally. There still you could argue that there's still coverage in some circumstances, in particular, where the employer acted for some reason other than the illegal use, like, for example, because of the suspected addiction or some assumed safety risk, and the individual has an actual disability other than OUD or is regarded as having a disability. Right? So once you get down into this area of the law, it can start to get angels on the head of a pin a little bit, and so it kind of twists your brain up a little bit. But I think the bottom line is, again, if the employer wants to rely on these illegal use exceptions, it's in its own best interest to try to find out whether the opioid use was actually illegal or not, because there could be coverage. Certainly, there will be coverage if the use was legal, almost certainly, and there could even be coverage if the use was illegal, or at least someone could argue that way. And this is the little summary for disparate treatment. As with any other disability, adverse action will not violate the ADA if it's required by another federal law, if the individual is unable to perform the essential functions of the job, even with a reasonable accommodation, or if the individual is a direct threat to safety. Okay, so those are going to be further issues that are going to be addressed. And just to take a quick look at a couple of those other federal laws, this one can be tricky because, remember, for the other federal laws, defense to apply, there has to be another federal law, and it's got to be federal, or regulation that's legally binding and that actually requires the adverse action, right? So a federal law that permits someone to take action on the basis of the opioid use is not going to be sufficient to establish the defense, right? What the other federal law has to do is require the action, and that in that kind of circumstance, you can argue that there is no way to satisfy both laws at once, and so the other federal law's provision kicks in, and it was what I was bound to do or required to do. Regulated industries like railroads and things like that, there are probably federal regulations that speak specifically to this, that disqualify individuals who use opioids illegally. These tend to be very, very complicated, but as far as I know, I'm not aware of any federal law or regulation that excludes someone on the basis of lawful opioid use. I would look carefully at those other federal laws to see what they actually say before concluding that they establish the federal law's defense. Turning now to direct threat, right? There has to be, you probably know all this, but the direct threat is a high bar. It's supposed to be a high bar. The employer is supposed to be able to establish that the individual poses significant risk of substantial harm that cannot be eliminated or reduced by reasonable accommodation. And it's an individualized assessment. Has to be based on reasonable medical judgment, most current medical knowledge, and or on the best available objective evidence. And it takes into consideration all these factors: the duration of the risk, the nature and severity of the potential harm, the likelihood of the harm, imminence of the potential harm, right? So, this is an area where the myths, fears, and stereotypes are potentially come to the fore, where someone learns that the person was addicted or is in recovery or something like that. And again, as a kind of a knee-jerk thing, they say, oh, that person's going to be a safety threat. What happens if they relapse and are on a bunch of opioids? Well, you can't assume that automatically, right? You have to do an individualized assessment, and you have to make sure that the evidence supports your conclusion. And there is evidence out there that a lot of people can function perfectly well in the workforce, even though they are in medication-assisted treatment or in recovery or have a history of addiction. The effects of the medication depend on the particular medication and on the individual. Right? They may have some side effects, but they might not have really any side effects to speak of. And there's again this declaration by HHS or SAMHSA: when provided at the proper dose, medications used in MAT have no adverse effects on a person's intelligence, mental capacity, physical functioning, or employability. All right, so myths, fears, and stereotypes. That's the bulk of the presentation, and but I want to go through quickly a couple of things at the end. These are things that don't require coverage. Right? These are the privacy provisions, and also the retaliation provisions. Looking specifically at privacy, right? Employers are only allowed to seek medical information at certain times. After a conditional offer of employment, if all applicants in the same job category are subjected to the same inquiries and exams. During employment, if the employer can show that they are job-related and consistent with business necessity, and when required under other federal laws or regulations, right? So that's medical information. However, employers are always allowed to do, quote, tests to determine the illegal use of drugs, as long as they're not done in a discriminatory way. So let's apply this distinction to questions. The questions like the following are going to be restricted because they're likely to elicit information about a disability. Have you ever been addicted to opioids? That's kind of obvious. Have you ever participated in a drug rehabilitation program? Again, gets at addiction. Have you ever used prescription pain medication at least once a day on 30 consecutive days? Again, likely to elicit information about a disability. In other words, restricted. You have to be able to justify that, or it has to be after a conditional offer of employment. Other kinds of questions are not restricted, and they have to do with use of illegal drugs. So if you ask a person, have you used illegal drugs in the last 6 months, that's fine, because that's not protected activity. Do you currently use illegal drugs? Again, not restricted. How about the standard opiates test? Right. So remember that the opiates test it tests positive if you used codeine, morphine, or heroin. Right. The positive test means that one of those three is in your system. I think it could still be reasonably called a test to determine the illegal use of drugs because it detects heroin. It's the test that is used to detect heroin. And so those kinds of tests are permitted at any time. Again, I want to just raise a question about this. This is something that you might want to think about. It's less clear whether tests for things like methadone, oxycodone, buprenorphine, etc., are tested to determine the illegal use of drugs because those things are all prescription medications, right? So it's like testing for, I don't know, diabetes medication or epilepsy medication or something like that. It's testing for drugs that could be legally prescribed, right? So query, when is such a test to determine the illegal use of drugs? Does it have to do with the employer's intention or whether or how the test is carried out or what? And again, in the federal context, you have regulations that essentially ensure that the test results are reported in a way that focus on illegal use. But in the private sector, there aren't those assurances. And I think in some cases you might be able to argue that, no, the test wasn't about illegal use. The test was about whether I was taking some sort of medication for a disability. That's what you were trying to get at. And that's it. I wanted to get through the last part so that we would. I'm looking at the time, and it's 12:59. But we certainly have time for questions. I think. Tim, what's the timing on this? Well, I'm happy to be doing it. I think it's a very interesting area, and it's an important one because a lot of people are getting swept up in it. And again, to my mind, the important points are, remember that opioid use and even opioid addiction aren't necessarily illegal use. And that's what opens up the door to disparate treatment claims and claims about reasonable accommodation that have to do with current addiction. And for a long time, people with chronic pain were treated with long-term use of opioids. Right? So some people were prescribed opioids just on an ongoing basis, and so they might be addicted, for example, and might want to get weaned off of the opioids, and so they might be covered under, the current disability prong.
Aaron, what do you find as as you've made this presentation? I know with justice and or similar presentations, what are the most prevalent concerns from, say, on the federal agency side? Well, what are people concerned with there?
Well, the Department of Justice, the cases that I know about are about access to public accommodations. So a lot of their cases have to do with access to medical treatment. So is a doctor allowed to refuse medical treatment to someone because they are addicted to opioids, for example? And the answer is no. I don't think that that federal agencies specifically have any kind of sort of special angle. At least I don't know of any. But since addiction can, reach anyone really, all of the considerations would certainly apply in the federal context, where the person might be currently addicted, might have a history of addiction, right? And you would have to go through the other federal laws. The ADA doesn't require you to violate regulations, federal regulations or laws, but you would have to go through the analysis to see whether you'd be able to rely on that.
Okay. Anyone have any questions at all? If not, thank you very much. And thank you so much, Aaron, for really a very interesting and informative presentation. As I mentioned, the presentation has been recorded, and it will be posted to YouTube, and the link will be sent to everyone who's listed as an attendee. So thank you very much again, and our Excel conference at EOC is next week. So all those who are attending, we look forward to seeing you there. Also, we ask that you follow us on Facebook and Twitter and for our next webinar. And we thank you very much.
Thank you very much.
Thank you.